We are recording. Welcome to the Ad Hoc Commission on the Discipline System ENEC Working Group meeting. I will call the roll. Ed Lear.
Here.
Melanie Lawrence.
Present.
Linda Schneider.
Here.
And Judge Wang.
Good morning.
All right, good morning, everyone. I will start off by, if there's any member of the public that would like to make public comment, can they please raise their hand now? I don't see any member of the public outside of State Bar staff. So and no hands are raised. So I will continue on. Thank you. And let me share my screen. Can everybody see my screen?
Yes.
Okay. So today's agenda, we're going to have a little bit of a timeline discussion because the timeline has been accelerated on certain circumstances and will maintain on other ones. And so this is, I just want to briefly talk about the timeline and what that means to this working group. And then also, we will have a presentation from Ron on the ENEC research on settlement. And 1 second, Dag is here now, so I need to allow him. So the timeline discussion, this is the timeline that I have presented at several meetings now. We have kind of reevaluated the timeline, and in terms of the recommendations that the full ad hoc commission is going to make, we have decided that it makes sense for those recommendations that are going to require statutory changes to be done earlier so that they can be taken up in the current session in 2022. And so what the plan is currently now is that those recommendations would be brought to the Board of Trustees at their March of 2022 meeting. And so we would have to have recommendations that would require statute changes to the full ad hoc commission prior to that March 2020 meeting. So either early March or late February 2022, if they will require statute change. There are different recommendations that wouldn't require statute change, but in terms of this particular working group, it may require a statute change because of the timelines that are in statute. And so that's what I just wanted to bring up briefly as we go along through Ron's discussion, because Ron kind of has, he's presenting, I know, one slide on timelines of the ENEC process. And so this is the Business and Professions Code 6101 that requires within 30 days of receipt of the conviction C cases, they be transmitted, and here it says the Supreme Court, but in actuality, so this is where the timeline is in statute. The rule of court delegates that authority to the State Bar Court. And so this is the rule where it's not the Supreme Court that actually receives it, it's State Bar Court, but it is still that 30-day timeline that is in statute. And so there has been talk about the ENEC process and how long that takes, and whether or not that would be possible with these conviction cases, because we've been talking about adding conviction cases to the ENEC. So that may require a statute change, and this working group will need to decide, is that statute change just for the C cases, and how would we go about that? And then another place in statute that talks about is, the original disciplinary proceedings of State Bar Court shall be public. And so these are where it requires it to be public. So as we go through this discussion with Ron and have a discussion in general on an ENEC, these are the where it's impacted in statute. So we'd have to think about what changes to the statute would make sense to allow for criminal conviction cases to potentially have an ENEC prior to going public, because that's what we're talking about, is prior to going public. We have these statutory deadlines. And so that's why I'm bringing up before I turn it over to Ron and he presents on the ENEC research that he's done to this point. So Are there any questions about the kind of change in timeline where we were accelerating those that require statute change so they could potentially be in a fee bill in the 2022 session? No, okay, it makes sense. All right, Ron, I'm going to turn it over to you now, and you can present on what you found.
Okay. Good morning, everyone. I'm going to share my screen. My presentation is based on a set of questions that came up during the discussion of ENEC as listed here. Primarily, it's about the outcome of ENEC. And here, the outcome is referring to the results of the ENEC sessions, whether it's one session, one hearing, or 10. That's not necessarily directly related to the outcome of the ENEC sessions leading to stipulation, because there's another step, even though it's usually immediately after the ENEC sessions have been completed. I'll get to that a little bit later. The second question is, of all of the cases that went to state bar court, how many cases is accounted for with ENEC process? That has an impact on the overall process of the cases going to state bar courts, and then the case age during the OCTC pre-post phase. That's we'll also have some data to share. And the process itself, the third bullet point, is defined by the beginning of the ENEC process, which starts from OCTC sending out a notice to the respondent about the opportunity for participation to ENEC. And the end of the process, in our calculations, the time is represented by the completion of the ENEC hearing. If there's more than one, then the last ENEC hearing is used to calculate the time. And then looking at the process itself, we also pulled some data to compare cases with or without ENEC in terms of the overall case age during the pre-post stage before the case was filed. Just one caveat about all of these analysis results is, while we made every effort to ensure the quality of the data, to make sure that the results are consistent across the different variables we look at, there are some limitations of the data. Partly it has to do with ENEC results are available consistently only for cases that went to ENEC after Odyssey. And because cases going to ENEC tend to be early part of the process, and cases that we pull to look at ENEC is based on the set of ENEC cases, the hearings and all the other related results, only after they started the process after March or 2019, after the implementation of Odyssey. So with that in mind, the first thing that we looked at is the result of the ENEC sessions. This is based on, as I mentioned, the cases that went to ENEC after Odyssey. Out of 300 to 400 cases, we need to make sure that we were able to identify the cases coming from the OCTC. So that resulted in fewer cases than initially we had the data available. And the table shows, in comparing ENEC results, we also looked at whether the ENEC sessions had counsel representation. Out of about 300 cases, overall settlement rate is about 25%. And you can see the difference in the settlement rate between cases with or without counsel representation. Those without the per ENEC sessions, the settlement rate is almost double those with the counsel representation. The second question is, then based on about 400 cases that's closed in the past couple of years, with the ENEC data, again, this is based on cases after Odyssey. Of all of those 442 matters in the sample, 128 were found to have an ENEC process initiated, which represent about 30% of all of the cases. This percentage will be significant when we consider the overall impact of the ENEC process. The process here is based on cases that were able to track from both sides of the process. That is, from the beginning when OCTC sent out a notice, a letter to the respondent about the opportunity for participation in ENEC, as I mentioned. And then on the State Bar Court side, we pulled data to look at the hearings scheduled, hearings held, and the timeline of the hearings. We also counted the number of hearings held per case or per matter. Here I grouped them into those that completed the ENEC process with the 1 hearing, 2, 3 to 5, or over 6. And you can see here more than 75%, 3/4 of the cases had 1 to 2 hearings completing the process. And the overall timeline measured in 2 ways. One is starting from when the letter was sent out until completion of the hearing. The second is when the submission for request of ENEC, which is about the time when the first ENEC was scheduled until completion of the hearing. So when you measure the timeline from submission of the request, the overall median time is 28 days. And if you go back to when the letter was sent out, you add about 10 days to the overall process in terms of a median time. And then naturally, the more hearings were held in a case, the overall process takes longer, ranging from submission of the hearing, it's 20 days to all the way to 122 days in terms of a median time, and then stretching out to the initiation of the ENEC process, starting from the letter, that's from 33 days to about 90 days overall. Summarizing all of those different time frame, and this chart just represents the overall distribution of the ENEC time. And the distribution shows here on the horizontal axis is the time measured in days. You can see here is very skewed distribution. That skewed distribution representing the majority of the cases complete the process, like 75% within 40 days and 90% within 65 days. And the difference between the 2 curves, one is starting from earlier in the process, the other is later. Overall, you can see the shifting to the right, adding about 10 to 15 days. This is the case age, starting from when the complaint was received until the case was filed with State Bar Court. And the cases are broken out into whether it went to ENEC, as well as whether the case had counsel representation. So the numbers represent the median time for cases in each group. With each of the 2 factors considered, you can see where ENEC was not involved and counsel was not represented, the amount of time for case age is the shortest at 355 days. When both factors are involved in the case, the overall case age increased by more than 9 months to 636 days. Here's a different view of the same case age data but it gives you a better sense about the impact of the two factors. The thick blue line represents cases with neither factors involved in the case. And the curve represents the proportion of the cases reaching disposition as represented on the vertical axis. So from 0, where every case starts, all the way to the top of the vertical axis, where every case reached disposition. And you can see, as an example, the 365-day mark at 50% for cases with neither ENEC nor council representation. And compared to the other 3 curves, moving to the right, that represents additional time taken when you have ENEC and council representation. But the key findings here in this visual inspection of the curves is the main difference is between cases with neither and all the rest. In other words, the impact of ENEC and council representation adds to case age incrementally. That's all I have. But then here, I want to just emphasize the 29% of the cases going through ENEC. That is driven by cases having certain characteristics, because this is not a random selection of cases going to the ENEC process. And the difference in case age that we see here has to be related to those case characteristics. So behind the data, we see the potential confounding factors that let cases going into ENEC, as well as having an impact on the overall case age. Without knowing the characteristics of the cases that made them go to ENEC, here we can only draw tentative conclusions about the difference without necessarily drawing a causal connection between the two. Yes.
Could I talk later? Ron, these numbers, like you said about the limitations, one, do default matters? Are they considered in this chart? Because default people are not represented and they don't ask for an ENEC. So those matters move more quickly through the system. So is that accounted for in your numbers? And
yes.
Okay. So depending on what you want to see in the data, that could conflate or throw off what your question is, i.e. whether or not being represented by council slows the system down in a negative way. I'm not sure if that's the call of one person's question, but if that is the call of the question, then the default matters throw that question or the answer to that question off, because people who are not represented and who do not ask for ENECs, of course, those matters close out faster, I would think.
Yes, that's very true. When we pull the cases as a sample to look into this, we want to make sure that cases that's not eligible for ENEC, for example, criminal conviction cases, they were pulled out of the sample. And then the other process-related characteristics or the underlying nature of the complaints, to the extent that they have to do with the ENEC, the more we have control, I think the more reliable and confident we can draw a conclusion about the impact of ENEC. So some additional follow-up would benefit our finding about the impact.
And then my other question is 80P in these numbers? The alternative discipline program?
Now, these are cases in all 4 groups. They were closed at the state bar court.
So that's the
ADP,
okay.
Where does it fit? I'm not sure.
Because ADP can be 3 years. So that can be throwing the numbers off too. I don't consider that a bad thing that a case exists for 3 years if they're in ADP. So I don't know if that's accounted for in your numbers.
But ADP process, that's post state bar court filing, right? The case age starts from
Oh, this
receipt
is
of a
just-
complaint,
Okay,
ending at state bar court filing.
okay, I didn't know what this number was capturing. So you're not capturing matters that went through the ENEC phase that eventually resolved in ADP. That's not captured in these numbers.
No, because what we're interested in is the impact of the ENEC process, participating in that on the case age for OCTC to bring it over to state bar court, not during the state bar court phase of the cases.
So all of these resolved with a stipulation?
No,
No, okay, I'm sorry. I guess I don't understand what it's capturing then.
so the case age over time at state
Okay.
bar court filing,
Okay,
whether by filing it's just forwarded and then brought over to state bar court. When it starts in state bar court, it could be the stipulation approved or going on to trial.
okay,
And that's why
okay,
default was also included here.
okay.
But it doesn't include the time. It doesn't track the time after the case was moved over to state bar court.
Okay, thank you, thank you.
So Ron, thank you for your work. In looking at it, my takeaway from your graphs and the metrics here are that an ENEC and a situation where a respondent is represented takes longer than if a respondent is representing him or herself. But none of the metrics that I see here goes to quality. And by that, I mean quality of results. So everybody on this call believes in the adversary system, and the adversary system works best when a respondent is represented by able counsel against able deputy trial counsel, and that's how we achieve the fairest results. So I'm not surprised that that takes longer than the no ENEC, no counsel blue line that we're looking at right now. So I'm not convinced that the graph we're looking at right now has any value. And so, I mean, it tells us about time, sure, but if we believe that the best results are the ones that are the gold line, then there's I suppose, a different conclusion. So I'm making a comment, but I'm also about to frame a question, and it's somewhat rhetorical because I don't think we can get the metric that would answer my question, and that is to say, is there a database that tracks the ENEC conclusion of the judge versus the ultimate result? Maybe Judge Wang knows the answer to that the best.
What do you mean by ultimate result?
Well, so let's say that there's an ENEC and the judge says, I believe this should result in a public approval. And then through the adversary process, the ultimate result, either through stipulation or through trial, is either a private approval or a stayed suspension. And so my thesis, I suppose, is that where respondent is represented, that the ultimate result through the adversary process would be a fairer result. And the reason that the case didn't settle at the ENEC is because there was additional litigation that needed to be done, that was done, that then persuaded deputy trial counsel that there was either more mitigation or less culpability than he or she originally thought. So that, and like I say, it's more of an observation and somewhat rhetorical. I think that the answer to that is attainable, but probably at great burden, because I don't know that the particular data that I'm looking for is input into the Odyssey system, and maybe Melanie and Judge Wang can speak to that.
Well,
I don't think it is from OCTC's side, no.
no, because we're not supposed to discuss mediation, right? So I think that's what I brought up in one of our larger groups, that's the challenge to the data. If you're looking for the efficiency of the settlement system in that way, we don't track internally, the judge's thoughts or what the parties had suggested, because that's privileged. So we don't track it as far as I know. And I think Melanie agrees with me. We don't.
Right. I
Yeah.
agree. And I do think it would be interesting to know if there was a way to get to it, but I'm not sure that there is. I'm wondering, I would just like to follow up on something that you mentioned, Ed, and in terms of this data. I think you said it didn't have value, but I actually take a very different perspective from it. I think it is important data. I don't think it is all the data, all the important data, but I do think it is some important data, because I think that what I heard earlier from Ron, and Ron can tell me if I'm wrong about this, but is that about 20 to 25% of the cases that go to ENEC settle with an ENEC. And if the purpose of an ENEC is to expedite and gain early settlement, then what we know is that about 20 to 25% settle. I don't know, is that what we're looking for? So I'd say that the other thing is that the fact that some of these cases do take so long, raises concerns related to the fact that these cases are confidential for the entirety of no public filing. And so from looking at it from a public protection standpoint, and what the public should know about their potential attorneys, that is potentially problematic, that we have cases that are, a year and a half to 2 years before there's actually a public filing. And then also just selfishly from OCTC's standpoint, when the focus is on this issue of backlog and resolving cases, and that backlog is measured at 180 days, when we see that so many of these cases are taking substantially longer than that, just as part of the pre-filing ENEC process, that's obviously concerning for us.
Sorry, everybody, I have to leave. Justin, I'll call you later. Bye.
Okay, thanks, Ed.
Thanks, Ed.
So
Ron, could I ask you just one more time, if you could just summarize very briefly the time difference between inception to filing, when there's just whether there's an ENC and whether there is not an ENC? Do you have that? Not without regard to whether the respondent attorney has counsel, but just the amount of time with an ENC and without an ENC.
You're referring to time from initial receipt of complaint to filing?
Whichever beginning point you want to use, whether it's the letter sent to the respondent attorney or whether, whatever beginning point, but just so that they're the same, just, how long it takes to get a case filed with an ENC versus without an ENC, just that basic data.
Well, this table shows the starting point from letter sent or ENEC request submitted. But the end point here is completion of hearing.
Okay.
It's not filing. So what I'm trying to capture here is what we consider ENEC process, not so much the entire case age from initial complaint all the way to state bar court filing. And the other timeline that I termed case age, that's where the entire process starting from complaint to state bar court filing was represented in this table.
Okay, so I think this one is the one I'd be interested in. And so it looks like when you do have an ENC process, it's about 628 days. And if you don't have it, it's 423.
That's correct.
Is that correctly?
Yes.
Okay, that's what I was looking for. Thanks.
And the starting point is complaint received, not the initiation of the ENEC process.
Okay,
Ron, I do think taking the default will make a difference. I think that the numbers are going to probably come closer together.
Yes.
And in terms of the court's perspective, following up on what Melanie and Ed said, from my perspective as a hearing judge who is doing the ENECs, the court's concern is it is really more shifting the burden from respondents' counsel to the court. So in terms of having the multiple ENECs, making sure the fair, we're on the efficiency subcommittee, I understand it. Ed made this point that this issue is kind of a blend between fairness and efficiency. So what happens is what's not covered by these numbers per se is when you're not represented by counsel, in order to make the process fair, the burdens are shifted from respondents' counsel to the court. So in other words, that's, my role is to make sure that the respondent understands what a stipulation looks like, what it means to admit to culpability, what the standards are and the rules. And so that's not really accounted for in terms of the numbers and the limitations of the data and the dual goals of efficiency and fairness. So I just wanted to, throw that out there as well.
Now, even though the information is not available directly related to what the judges and the parties think at the end of the ENEC session, would ultimate outcome in terms the matter of case disposition resolution, whether it reached reproval, suspension, or other outcomes in comparison to whether ENEC have been held or whether counsel have been present, would that be useful in looking at this question of the outcome or quality, even though the same kind of issue of confounding factors may be at play there?
Yeah, I think that may be more confusing than it answers, but I don't know what other people think. But I don't know. That just puts us in another rabbit hole. But I mean, how do you measure fairness, right? So I appreciate OCTC's backlog and how they do a yeoman's job, in my opinion. I think they do a fabulous job, Melanie. But how do you measure it? So a case that resolves in 600 days where respondents felt like they've been heard, is that more valuable than a default matter that closes in, within the timeline, right? So those are the things that aren't quantifiable by the numbers. So, but I guess that's why we're in this working group.
I agree with you completely that you can't know everything just from numbers. You certainly can't tell quality from numbers. I think the numbers are just one of the factors that have to be considered, when you're considering these issues. So, how much time it takes to get a case on file is important in the sense that, the public is notified, and also just the amount of time a respondent attorney is practicing, if they're dangerous to be practicing, public safety issues. So that's where the time comes in, not to mention the scrutiny, the OCTC on getting these cases filed as expeditiously as possible in the backlog. So time is only one factor, but it's, a factor to be considered in the balance of all things. That's kind of the way I look at it. At some point, are we going to be talking about I know, we're kind of focused on the criminal cases, have been so far, but at some point we'll be talking about the ENEC process itself and whether any changes could be made to it to make it more efficient and perhaps even more effective.
Yeah, and that's where some of this presentation, like the 25% of cases in the ENEC, that's where we want to kind of think about, okay, that's a quarter of cases. What is each side think about, is that an appropriate amount? And if it isn't an appropriate amount, what could potentially be done to either increase it or decrease it, or even keep it around the same, but there are changes. I mean, we are open to those things as well. We have been focused on the criminal conviction cases, and I did want to kind of go back to that because that may potentially require the statutory change. With the C cases, because there's all variants in C cases. And unfortunately, Ed is gone. I'm going to need to follow up with Ed on this question. But the question I'm posing to the group is, do we think that we'd consider all C cases, or is there only a subset of C cases that we would consider doing an ENEC for? Because like we've talked about, the purpose of the ENEC with the C cases is to keep it private and not make it public right away. And so are there types of cases where it doesn't make sense for a C case to go through the ENEC process because of, it's so severe that we want to alert the public as soon as possible and get it? And if so, kind of what are your thoughts around that? Is there a type of case? We don't have, I mean, we can kind of bring the different types of C cases back, but that's, I think before we need to decide on the parameters of what types of C cases we're looking at, and then go into how long do we think we need to modify the statute in terms of number of days to make that a potential viable option, that we have enough time to do that process.
A summary disbarment cases, Justin, those are summary disbarment, so we don't see those. So the felonies, and when was the, Melanie, when was the amendment? What years do we, that's with the statutory modification, do you remember? So with the backlog, so the fingerprinting cases, the ones that aren't captured by the summary disbarment still come to the state bar court. So, but post the amendment, we don't see those. So to answer your question about the patch, Justin, we need to take a look at when that summary disbarment and if that makes a difference. And then maybe, I mean, I'm just throwing it out there because you asked, but going back to the modification, wouldn't it be simpler or more elegant to modify the 6086.1, the definition of public matters, and we don't even have to worry about the 30 days or everything? OCTC still does the 30 days. It's just that we modify the 6086.1 in terms of defining that gap. Does that make sense?
Yeah.
So those are my thoughts to your question.
Yeah, I agree with Judge Wang clearly about the summary disbarment. I mean, frankly, I think that there are very few criminal conviction matters that probably resolve with private discipline or would resolve with private discipline. I think I would have to give more thought, and I think there probably need to be more discussion about how actually we would categorize potential cases in terms of what might resolve with private discipline. But maybe one way of doing it is, as Judge Wang suggested, an easier way to do it.
Is there any data or research that would help make that decision that we could bring back to you?
Well, I think you may have already done some of it, and I missed the last working group meeting. I'm not sure about what C cases have previously resolved with private reprovals, for example. I think the other, and I'm not sure if this was captured in your research, but the other things that come to mind is C cases that are resolved with ALDs or warning letters. those would also be non-public. Well, they wouldn't even be discipline, frankly.
The last time we looked at the C cases and the outcome of those C cases, actually in comparison to all of the other cases, we saw in the past couple of years an increase of C cases resulting in reproval, representing about 10%. But then if you look at the number of cases of C ending in reproval, it's about 1 or 2, because the overall C cases compared to all of the other cases is relatively small. So the volume of cases is fairly small. So one of the things would be to look at pre-fingerprinting versus afterward, Corey versus non-Corey, and compare the results, and then looking at the trend of non-Corey cases and potentially eligible for reproval, what it looks like.
Yeah, I agree.
Okay. Is there any other thing that we can bring back? I mean, this is a constant discussion. I appreciate everybody's time today. And I think that, you know, I know Ron has a couple of things that we're going to bring back to the committee in terms of taking the defaults out to see whether actually, because that'll show a little more accurate efficiency, whether represented, non-represented. And what we just stated now to see the non-Corey cases will give us a better idea. So, and I may be in touch in between now and the next time we meet to see if so we can have a better discussion on the limitations of C cases and the types that could be potentially be eligible with the data. But is there anything else that we can bring back to the working group? And also to talk about what Linda said on overall efficiency, are there things that we can, you know, discuss, set up, so we can have a substantive discussion on, you know, the overall efficiency of the ENEC. I think that slide was, you know, the timeline slide where it said 30, I think the median was 33 days if it's just one ENEC, but then it really kind of gets a lot longer with the multiple ENECs, which, you know, Judge Wang, in the past, you've said for non-represented attorneys, it's very useful to have multiple ENECs. And I know OCTC would like it just to be one ENEC, and so that timeline on efficiency, and we can have a discussion on that. But in general, are there things that we can bring back to the working group?
Back what I think Melanie brought up, what I brought up last time in terms of the statistics on the approval and with the ENECs. I don't think the data captured ALDs or private. It only captured private and public approvals versus regular outcomes. It did not capture dismissals, and I don't know if we can, or I don't know if that can be captured. And back to Linda's point and what Justin just raised, in terms of the 33, so the rules require, well, they suggest that we hold the ENEC within 15 days of the request. And as Melanie knows, she'll start laughing. To corral, you know, cats, right? Where the court's availability, both respondents' availability, when you throw in counsel who are represented, we're not getting it in with 15 days. It's just not happening. And so I don't know how to change that. So yes, the rules say 15, and I just saw the, was it average 33 or 30? That's double the, you know, the time that the rules, you know, suggest. Yeah. So I don't know how else to kind of narrow the gap. I know I brought up, because I you know, I have no experience in that, I keep calling the 20-day meet and greet, Melanie. Well,
20, yeah, the 20-day, it was called the 20-day meeting. Yeah.
Yeah, the 20-day meeting, I don't know. I don't know if having that, would that narrow the, I know.
Well, yeah, I mean,
I
and,
think it's the decision not to do it, and I have
Right.
no idea, because I have no
right.
data point for that or a reference point.
Right. And there wasn't a rule for it. It was a policy that the
Right.
office had.
Right.
Yeah.
Yeah.
And as with so many of these things, the big concern with us is the consistent delay. And this may be beyond this working group. I don't know, somebody can tell me. But I mean, one thing that I think about is that given that if we think that the ENEC process should continue, whether it's in its current format or otherwise, if there would be a way to not include the ENEC period in the calculation of the backlog, because that is such
Right.
extreme pressure for us.
Right.
That is one of the driving factors for us trying to move more quickly. That's one, as I mentioned, I do think the other concern is, just public notice, but setting that aside, if we think that we want to continue this process and we know that it takes longer and we think that it's more fair, if someone is represented or if they have more opportunities with the court, then it doesn't really seem realistic to include it in the overall backlog calculation. I'd like to see that change.
That makes a lot of sense. Melanie, I have a question for you, and just from your personal experience and running the unit, what do you have an opinion about ENEC? How do you, what do you see? What's the value of it from your perspective, and just what do you think about it?
I mean, I think that it has some value. I think in particular related to unrepresented respondents. I really do. I think it is an opportunity for them sometimes to hear from someone who is not us. And, perhaps that will help inform their decisions. So I think that's a good thing. I do think that we feel, and it's a feeling, so I'll own that, it's just a feeling, that too often, in particular when there is a respondents council, that it is used as a delay tactic. And that's frustrating for us from just a time standpoint, but also from a public protection standpoint. And so, but I don't know how you sort of cull those out. And again, it is just a feeling. But, I think that the ENEC process, if you look back at it historically and why it came to be, it was born out of the fact that, for a period of time, the state bar was shut down because there was no fee bill. And as a result, there was a glut of cases that had been accumulating. And in order for them to move faster, the theory was that if we had people getting in for settlement conferences earlier, that it would potentially resolve cases faster, and that we could move through that volume of cases. I think that there have been some looks back at it since then. And I don't think that there has been a consensus that it has achieved that goal. And I think, sort of in some of what we're seeing now, and especially in terms of timeliness, if efficiency is the goal, I'm not sure how efficient we're really being. And if part of the goal of an ENEC is resolving cases in particular that are not going to result in a public filing in any event, there's value in that. But the reality is many of our cases are going to resolve with some kind of public discipline. Even if it resolves at the ENEC stage by stipulation, it often is a public discipline. So So that's sort of a long way of saying that, I definitely think that there is some value in it in some instances, but overall, I think it really felt like a barrier for us.
I see. Well, thank you for sharing that. That really helps to understand both sides of it. Yeah, thank you. Yeah. So, I mean, if you really could just have one ENEC, maybe it would provide the value that it offers and at the same time not be such a roadblock to the process. I mean, according to what Ron said, we're adding like 205 days on average when you have the ENEC versus so.
Yeah. And, and to that point, one thing I wonder about is if for example, in the cases where there are multiple ENECs, let's say, two or more, is the resolution with public discipline? Because if it is, then I'm not sure that tacking on all of those days makes sense. We can resolve cases post-filing on our own or with the help of the court through a voluntary settlement conference. So I just don't know what we're gaining in terms of that early process.
Thanks.
Thank you. I think we have our marching orders for the next meeting. I see that in order to make a decision on what types of cases would be eligible on the C cases, getting ultimate outcomes of what the C cases are, and then also the differentiation between the old cases versus the new cases going forward, the fingerprint cases versus the other cases, and seeing the ultimate outcome public, is it public? We can provide that. The taking out of the default matters. Ron, I think are you clear on everything that has been requested of you?
Well, and if I could ask, because I don't know if I was asking for it, but if I wasn't, I will. Are we able to call out of the cases where there are multiple ENECs, if the result thereafter is in some form of public discipline? Yes.
Ron's on mute, but I saw him say yes.
Okay. I would be interested in that.
Now I have a follow-up on that. For those with a public discipline, are there also different level of severity? For example, even for probation, that might be suspension. Suspension might be 1 month versus a 6 month. Are all those things part of the ENEC process to sort out?
I'm not sure exactly what you mean. I think some of those specifics are sorted out at an ENEC potentially as part of whatever the level of discipline is going to be. But for purposes of what I was asking, I'm not sure that it matters what all of those details are. Now, I think Ed Lear, if he was here, would say it does matter, because although I don't know how you measure it, because again, I think his point is, well, maybe they got a better deal, if you will, because they went through that ENEC. Right. So, but I don't know how you measure that. But my purpose in asking the question is, if the purpose of an ENEC is a potential earlier resolution, then the fact that you're having multiple ENECs and stretching out the process, so you're not getting an earlier resolution, starts, as far as I'm concerned, having less value to it, particularly from a public protection standpoint, if ultimately the resolution is still for a public discipline. Because again, we can resolve a case post-filing for public discipline on our own or with the help of the court. But the fact that it continues along in an ENEC process keeps those cases confidential until there's a public filing. And to me, that's a public protection issue.
Yeah, we could look at the outcome in terms of whether it results in public or private discipline. The type of a public discipline in terms of the severity as measured by length of suspension or the presence or absence of suspension, they are available, or they're a little difficult to come by if they are relevant.
Okay. Is there anything else? Okay. Well, I appreciate everybody's time, and we will see you in 2 weeks.
Thanks very much.
Thanks.
Okay.
Thanks, everyone.
Thanks.